Members, good morning. It is the appointed time and we have a quorum. I call to order today's meeting. I welcome the team from the government. We have representatives from the TLB, the police, the transport departments, and the DOJ. Members, please note that concerning the invitation for public submission concerning the bill. As at the deadline, the Secretariat has received 3 sets of public submissions. A consolidated reply has been submitted by the administration, which has been sent to members just now. So please read the reply. At the last meeting, we have completed scrutiny up to Clause 3 of the bill. If there are no further questions, we will resume from Clause 4. Now we invite the administration to bring us back to Clause 4 of the bill, C918 of the Chinese version, and 002 of the markup copy. Please press the button if you have any questions. Mr. Percy Leung will take us through the bill. Thank you, Chairman, and good morning, members. We will now continue scrutinizing the bill from Clause 4. That is also pages 2 to 3 on the markup copy. Clause 4, adding the new Section 39U to A, that is a person who is required to surrender the license for driving is to be regarded as having complied with the requirements if the person produces his or her electronic driving license to the police officer. Now, under certain circumstances, if the police officers have certain grounds, for example, the driver failing to pass the breathing test, the driving license can be suspended for 24 hours. Please continue. Clause 5 of the bill. Page 4 of the markup copy. Clause 5 amends Section 42, brackets 2 to allow a person to bring along an electronic device on which his or her electronic driving license can be readily displayed, and as a duplicate of the driving license. Now, at present, the requirement for bringing along the physical license is set out in Section 42, brackets 2. That is, a person bring along his or her driving license or a document issued by the commissioner indicating that the person has applied for the renewal or a duplicate of his driving license. Now, under the new Section 42 2B, we added the description that the person may bring along or readily avail himself or herself of an electronic device on which his or her electronic driving license can be readily displayed. Mr. Andrew Lam. Thank you, Chairman. 4 minutes. Thank you. Now on the bill, we have seen wordings, including representation, and produce, and display. I fully understand the need for anti-counterfeiting features. But if you look at section or part 2 in terms of the verb produce, it requires the driver to display or produce the electronic driving license by way of a certain platform. For display and produce, I was talking about representation, but when it comes to produce or display, the description isn't there. So I quoted an example last time. That is, I have downloaded the app from your platform, but can I display or produce my EDL with my own platform? It's not a flaw in terms of anti-counterfeiting feature. It's just a matter of convenience. Now, when it comes to 1110A, there is another mention. So if you think the manner of drafting as present is fine, that's okay. If not, I think you need to specify that in producing or displaying the EDL, you need to use the same platform as well. That would be more safe. Mr. Percy Leung. Thank you, Chairman, and thank you, Mr. Andrew Lam. We did consider the scenario mentioned by Mr. Andrew Lam concerning obtaining the EDL via the electronic platform. We agree that we need to be very clear about that. So in terms of the definition for the EDL to be valid, it needs to meet the requirements, that is the electronic representation of a driving license. So that includes being in the form specified under Section 110A1A. Second, the EDL must be obtained through an electronic platform specified under the same Section 1C. So those two conditions must be met. For the driver to be able to comply with the requirements to represent the EDL on produce and display. It is about presenting or showing the EDL obtained via the electronic platform, as mentioned previously. So I think these two provisions have served our purposes. I will defer to the DOJ as well. DOJ, please. Subsequently, in Section 110D brackets A, we will specify that in producing the EDL, it must be through an authorized electronic platform. So that requirement is clear. Mr. Lam? The last time I mentioned that there may be some uncooperative drivers. So I have obtained the EDL through the authorized platform, but I'm just presenting the EDL to you via the, say, PDF format. Am I allowed to do that? Now, after reading the bill for 2 or 3 times, I don't think this is very clear. So I just wonder whether you should be clearer in terms of the verbs produce and display. If you think it is fine, then I have no further questions. Ms. Leung, any further comments? Thank you. Next, Mr. Chen Siu-Hong. Thank you, Chair. I just want to make sure that we are now at session 42, page 0004, right? My apologies that I have just spoken in another meeting next door, and I've just arrived. Now, I share the same concern with Mr. Andrew Lam's. Produce and display. In the previous meeting, I've asked a similar question. Critically, whether it is produce or display, you are not allowed to present the EDL through a screenshot. Now, last time this was explained that it was not allowed. So to make the bill clear, you must specify that you must display the EDL through the electronic platform. Only that screenshot with the pertinent anti-counterfeiting features will be accepted. So I begin to understand the government's stance on this. But I have a suggestion. In terms of publicity and education, you need to focus on this message. Now, when several electrical members were given a tour as the traffic enforcement section, we understood the operation much better. So I think you need to offer a package of information to drivers to avoid misunderstanding. Now, Section 42 2 brackets B carries or can readily avail himself or herself of an electronic device on which the electronic driving license can be readily displayed. Now, what does it mean by readily? When there are disruption in the internet or when there is a mechanical fault with the phone, or if the phone runs out of battery, then the driver cannot readily avail him or herself of the device to display the EDL. Will that cause trouble? So how do you interpret the word readily? Do the drivers have to display or produce the EDL within a minute's time? Beyond that, it will not be counted as readily.
主席，多謝陳議員。
Mr. Lan, thank you, Chairman. Thank you, Member, for the question. We have considered this point. What does it mean by making the license readily available? When an enforcement officer handles a case, they should know if the driving license holder holds a valid electronic driving license, and the officer should be able to scan the license very quickly. If the holder's electronic device is not connected to the internet and is, say, turned on to the airplane mode, then that person would not have made the license readily available to the enforcement officer. During the drafting process, we have talked to the DOJ on how we can better express our intention and to make things flexible for frontline enforcement officers. Chairman, if I delete the words readily avail, there wouldn't be too much of a difference. Are you worried that someone may deliberately slow down the showing process of their e-driving license? How does it differ from you're asking the drivers to show their physical driving license? They may have to, say, fumble their bag or wallet in order to produce their physical driving license. What difference does it make in terms of enforcement if you delete the words readily avail from the clause? Well, there is a difference because currently, as soon as the person produces the physical driving license, then we can check the details. But for electronic driving license, as we mentioned, there is a process. The driver have to turn on the application, and the application will have to read the details from the backend system. If the device is not connected to the internet, then the enforcement officer will not be able to read the details of the e-driving license. In this case, enforcement officer will not be able to check the details speedily. We've talked to the police and the DOJ. We think that by putting the words readily avail, it will facilitate enforcement. Chairman, I'd like to further follow up. The intention of introducing EDL is to make things convenient for the people and to offer an optional supplement to drivers so that they can choose either to show their physical or electronic driving license. There could be things that happen out of the driver's control, such that he or she cannot produce or display their electronic driving license. Even if you ask the driver to produce their physical driving license, the driver may still take, say, 10 to 15 minutes in order to identify the driving license in their vehicles. What does readily avail mean? I don't really get it. Mr. Lang, anything to add? Thank you, Chairman. We thank Mr. Chen for his concern. Let me further elaborate. We want to make things convenient for the people by introducing EDLs. We offer them with an optional supplement to either carry physical or electronic driving license. But we have to also facilitate the enforcement needs of frontline officers. Say, for example, if we don't add the words readily avail in the clause, then some drivers may deliberately make it difficult for the enforcement officer to read the EDL or scan it. We make things convenient for the people by offering an additional option, but we think that we do need to keep these two words here in the clause. Chairman, by introducing this convenient measure, people still need to carry the physical driving license because they are worried that they may not be able to make the EDLs readily available. I hope that the administration will note this. No other questions? Please proceed. Thank you, Chairman. Now we move on to Clause 6 of the bill. That's page 5 to page 6 of the marked up copy. Clause 6 is to amend Section 43 to accept the production of e-driving license first. We're going to amend Section 43 bracket 3 such that if anyone fails to produce a driving license upon request, then they would have committed an offense. And we are also going to amend Section 43 bracket 3 by adding paragraph A such that if a person fails to produce e-driving license or physical driving license upon request and have not within 72 hours produced the driving license or physical or electronic ones, will commit an offense. We are also going to add 4B such that a person who is required under subsection 2 to produce his or her driving license is to be regarded as having complied with the requirement if the person produces his or her electronic driving license to the police officer or the commissioner. We're going to also make technical amendment to Section 43 bracket 5. We amend a driving license and substitute it with a driving permit. So that's international driving permit instead of international driving license. Any comments? No? Thank you. Please proceed. Mr. Chan Xiu-hong. Thank you. What happens if a driver cannot produce the physical driving license? Well, now we allow the relevant drivers to display or produce the driving license at a nearby police stations within 72 hours. Now we have an electronic driving license. Are we adopting the same measure? When a police officer asks the drivers to produce a e-driving license due to various reasons, for example, the mobile phone running out of battery, the driver cannot produce the driving license, then they would have committed an offense. But we should allow them to produce or display their physical or electronic driving license at a police station within 72 hours. Is that right? I'd just like to clarify, because people are worried if the requirements were restricted with EDLs. The understanding is correct. Thank you. I'd like to go back to the words readily avail. I think that's really redundant. I may be charged if I don't show the EDLs efficiently. I should be able to produce the EDL in 72 hours at a police station. Am I right? That's the same as if I forget to bring my physical driving license as I'm driving. Yes, you are correct. You can refer to page 6 of the marked up copy. The 72-hour requirement is also applicable to electronic driving license holder, and that's retained in the new bill. So a person can either show the electronic or physical driving license at a police station within 72 hours. Ms. Judy Chan, thank you. While producing a driving license to a police officer at such police station or other official address as specified. Does official address include email address? Thank you. Because while we ask the person to produce either the electronic or physical driving license, they have to present themselves at a police station or other official address. Well, when we discuss the policy matters of the bill, it is said that in the future you may allow for a screen cap of or screenshot of a driving license. By producing a screenshot, it's not equivalent to displaying the EDL, am I right? We ask drivers to produce the EDL in a way that is in conformity with the law. There are a lot of anti-counterfeiting features in the EDLs, so screenshot will not be accepted as a way to fulfill the legal requirements. That has already been explained in the definition of the EDL, as in how the EDL is to be generated. No further questions, please proceed. Thank you. Now we come to Clause 7 of the bill. That's page 7 of the marked up copy. Clause 7 amends Section 67. It's about power to seize document, vehicle license, or registration mark. And that's not applicable to electronic driving license or electronic driver instructor license, because e-driving license will not be able to be seized. That's why it's not included in the clause. Ms. Chan, or rather Mr. Chan. I know that this provision is about seizing document, physical license, or registration mark. In the bill, I only see the sentence, this section applies in relation to an item that is mentioned in section so and so, but no reference to electronic driving licenses here. I think that we should just say that this section does not apply to electronic driving license. When I read the bill yesterday, I didn't really understand. In 1A, you just exclude the section about EDLs here. I think that a more simple way to draft it is to include the sentence, this section does not apply to EDLs, instead of including everything else that is included. Thank you. I will see if the DOJ has anything to add. Apart from being clear and transparent, we have to make sure that if there is further amendments, we need to know what section, what kind of license or documents this section applies. We're going to talk about falsifying document in the later clauses, and there we will talk about what section applies to EDLs. DOJ, do you have anything to add? We want to talk about what documents this section applies to. This is the way we draft the laws. We usually say what this section applies to, instead of seeing what this section does not apply to. The effect is pretty much the same. You can just say that this section does not apply to bracket EA and bracket EB under section 2. Any further questions?
主席，
Please continue. Thank you, Chairman. Clause 8 of the bill, pages 8 to 9 of the markup copy in the Chinese version and 8 to 9 in the English version. Clause 8, amending Section 71 of the Ordinance. This is a textual amendment without affecting the substantial contents of the bill, of the ordinance. Section 71, subsection 1, we are trying to improve the readability of the text. Subsection 5, we are correcting the Chinese text to reflect the meaning of deposits in the English text. We are repealing the Chinese word 交出 and substitute it with 存放. Mr. Andrew Lam. Yes, I understand what you are trying to do, but I don't think you are improving the Chinese translation at all. The English verb is deposit. I think you are taking a step towards the destruction of the Chinese language. If you are saying 存放 in the court, I can accept it, depositing the text within the court. But what Chinese it is, deposit something with the magistrate. You can't say that in Chinese. If you don't like the word 交出, you can say 交存. It still means deposit. So the Chinese translation is really problematic. I have a very strong opinion on the translation. If you are seeking clarity, and if you want to translate the word deposits better, I think you are doing the opposite by saying 存放 something with the magistrate. Mr. Percy Leung, I also agree. But Mr. Leung, I think the writing is 存放 with both the courts and the magistrates. I'm not unhappy with the verb itself. However, deposits with convey the message of handing something over to someone. So if you really think we should use the Chinese language like this, I have nothing to say. Now, since you are saying you want to improve the Chinese translation. I don't think, even with the amendments, it is ideal. So this is my strong opinion. Please consider it. It does not affect the operability of the bill, but I'm really finding the Chinese translation hard to swallow. Mr. Leung, thank you. Concerning the word mentioned by Mr. Andrew Lam, we have the same verb at various locations. For example, 1B, the last sentence, it says that cause the license or permit to be forwarded to the commissioner as soon as it is deposited with the court or magistrate. And also, there is another mentioning of the action. Now, in subsection 5, the original text is that any person who fails to comply with an order made under subsection 2 for the deposit of a driving license. So we are simply changing the Chinese version of the provision because that's a proactive action. So I will defer to the DOJ for the supplement. Ms. Lai? Thank you. Concerning the Chinese counterpart of the word deposit, there are similar translations in other ordinances. So considering the consistency, we would like to use the same Chinese translation, that is 全防御. Chairman, I'm merely raising this point. I don't think we should copy other ill-drafted text. In Chinese, you can say 全防御 with a place, but not with a person. But if you are saying that this is still clear enough, well, I'm not taking issue with the operability of the provision. I'm just saying that the Chinese translation is bad. So you're talking about the amendment at section 71 brackets 5. No, I mean section 2. You can say 全防御 with a place, but not with a person. You can pass something to a person, but you cannot deposit it with a person in Chinese. Any views to the contrary? Next, Mr. Duncan Chiu. Chairman, concerning revocation of driving license. Are all the systems connected? Say if a person has contravened a traffic offense and will have his driving license revoked, then are the systems for the driving license, the probationary driving license, and the international driving permits interconnected? If the one for international driving permit is not connected, then the driver may still be able to drive elsewhere. And also, if I suspend or revoke the electronic driving license, can the driver still use his or her physical driving license to drive in Hong Kong or overseas? Now, as Mr. Andrew Lam pointed out, someone may have taken a screenshot of the driving license. Many overseas jurisdictions have mutual recognition of driving license with Hong Kong. Now, if the driver presents the screenshot of the driving license before the revocation of his license to an overseas jurisdiction or overseas authority, how can we update the overseas authority that the person's license has been revoked? Otherwise, with a duplication or a screenshot, the driver can still drive overseas. Mr. Leung, I will defer to the Transport Department. Ms. Amy Lee. Thank you, Chairman, and thank you, Mr. Duncan Chiu. Now the court system has a link, has been linked up with our transport record system. Now when there is an update in the court system, our backend system would receive a prompt for us to revoke the driving license in our system. So no matter what happens with the physical driving license, the driving license would be invalidated on our system. What about international driving permit? Now, under the existing legislation, the court has the power to invalidate the full driving license locally. So if a person has their driving license disqualified locally, it doesn't mean that they can't drive overseas. What about my second question? What if there is a screenshot of the driving license? Can the driver use that screenshot to apply for other driving licenses overseas? How can overseas authorities have access to the updated information on your backend system? It depends on how the overseas authority provides recognition to our driving license. Now, if there is a regime of mutual recognition, then the person must present their physical driving license to the overseas authorities. Of course, after the passage of this bill, we will notify the partner jurisdictions that we have updated the law, and that when the person's driving qualification is invalidated, it will be shown on the record. I think the enforcement is a bit different from the provision. Now, 81D, it says that upon the commission of the offense, then the relevant documents would be deposited with the court or the magistrates as soon as possible, including the international driving permit. So if the person deliberately keep the international driving permit from the court, then we have no way to know. Ms. Lee? Sorry, maybe I wasn't clear. If the court rules that the driver must surrender all the driving licenses, then they must do so. Of course, the court does not know what kind of driving licenses the driver is holding, but from our back-end system, we will make sure that all the driving licenses are suspended or invalidated. That brings me back to my question. Linkages of the system. The person can keep the physical international driving permits and produce it to an overseas authority, and that authority will not know that the driving license has been invalidated. Now, if the order is that all driving licenses must be invalidated, then according to the law, the driver must surrender their driving licenses or permits to the court within a certain period of time. Then the record would show that what kind of licenses have been surrendered. That's my point. If the systems are not linked, then that would be a problem. So this law only regulates the behavior of the driver in Hong Kong. So the court does not know whether the driver has surrendered the international driving permit. Let's say there is a scenario, my driving license has been revoked, then the court would give me some time to surrender my driving licenses. Then the court would have a record on what kind of driving license I have surrendered. Is it the card or is it the international driving permit as well? So when that permit is surrendered, then naturally, they cannot produce it to an overseas authority. But does the court know that the driver has an international driving permit? The court's order should cover all the driving licenses, including the international driving permit. The court should have known that because the permit is also issued through the TD. So after surrendering the international driving permit, in theory, the person cannot drive overseas because they cannot produce a physical international driving permit. I don't think that an electronic version would suffice overseas, according to my experience. Yes, they need to present the physical documents to the overseas authority. Thank you. Another question, another issue. When there is a case, when there is a prosecution, the TD would be informed, and the TD would provide information to the court on the kind of driving licenses that the driver holds. So the court would be made aware of what kinds of driving licenses the driver has. But that is limited to driving licenses issued in Hong Kong. Next, Mr. Chan Siu-Hong, Chairman, concerning Section 71, notification and effect of an appeal against disqualification. Now, the major amendment is that the Chinese verb 交予 has been replaced with 存放, deposit. So if a driver is required to deposit their driving license with an authority, then the Chinese text in its original form, 交予, is clear. However, if you are changing the translation to 存放, well, I don't know how you are keeping my surrender license. No one understands how someone deposits the document. The original Chinese translation, however, 交予, was much clearer. So in the new subsection 1b, there is also the mentioning of depositing the documents with the commissioner. Now, in terms of 交予, which essentially means passing over something, that would be much clearer.
DOJ, please. Ms. Lai. Thank you, Chairman. Regarding amendment to Section 71, we want to first deal with the English version of the ordinance. Under Section 71, bracket 1, the words "as soon as it is produced to the court or magistrate in accordance with the provisions of Section 2 is used. After introducing the EDL, we think that the words "produced to the court" may not align with the word "produced" we use in other provisions. Under Section 71, bracket 2, we ask, well, the court or magistrates may order a person deposits the driving license with the court or magistrate. In Section 71, bracket 1, however, we ask the driver to, as soon as it is produced to the court or magistrate in accordance with the provisions of Section 2, the use of the words produce is not in alignment with subsection 2 because we should use the same words deposit instead of using produce in subsection 1 and using the word deposit in subsection 2. That's why we also amended the Chinese rendition in parallel. Chairman, I still don't get it. When a police officer asks the driver to produce the driving license and have it deposited with the court or magistrate, as a regular driver, all I need to know is that I have to hand it over to you. I don't need to care how you deposit it. I don't know why you have to change the word. It seems very confusing if we just read the Chinese rendition. I didn't know that this was a corresponding amendment. You may say that producing and displaying driving license are different because sometimes you don't have to hand over your device to the police officer. After you have handed over your physical driving license to the court, then you will not be able to drive because you no longer hold a physical driving license. Why don't you say that Section 71 only applies to physical driving license instead of electronic driving license? Just like Section 67 bracket 1A. We said that the section does not apply to electronic driving license. When it comes to EDL, I know that if a driver has their license revoked, then they will not be able to display or produce their EDL on the specified electronic platform. So it seems that this section has nothing to do with electronic driving license. Because if you have your EDL suspended, then you wouldn't be able to display it on your electronic device. Now coming back to this clause, why don't you just keep the words 交予 or use both 交予及存放 as the Chinese translation to deposit? Mr. Lan? Thank you, Chairman. Thank you, Mr. Chan, for the question. Section 71 is about what action the court or magistrate should take after an order has been handed down. It's about orders issued by the court or magistrate. It could be an order to ask the relevant person to deposit the license with the court or magistrate. When the court or magistrate makes the order, they will refer to the relevant provisions, and they will look into how the driver should comply with the order. Regular members of the public may not be familiar with the procedures. They may make inquiries if necessary. But this section actually targets courts and magistrates. Mr. Chan's point about EDL is correct. This section is about physical documents. For electronic documents, then they would be revoked automatically in the back-end system. Chairman, if a court or magistrate's order that a person surrender their license and documents, then they will have to do so. That much is clear. But should the court or magistrate direct the relevant person to also freeze or surrender the electronic driving license on top of the physical driving license? If such a requirement is not included in the order, will the enforcement officers be made aware of the order such that they can take order in accordance with they can take action in accordance with the order. Thank you. The procedures is the same. Now, if a court orders that a person must surrender their driving license after the Transport Department have received the relevant order, they will update the information in the backend system. Currently, we adopt the same practice without the electronic driving license. In the future, we will also invalidate the EDLs of the relevant person. Mr. Andrew Lam. Thank you, Chairman. The spirit of this section is to ask the relevant person to surrender the driving license. I use the word surrender instead of deposit. And I prefer it. Because if you use the word surrender, then there wouldn't be a problem as to what should be deposited. What happens if the person takes their international driving permit somewhere else? The word gao in Chinese is extremely important because it means handing over and surrendering something. Anything to add? A DOJ? Mr. Lam, I think that the word surrender and deposit are pretty much the same in terms of meaning. If I deposit something with you, it does not mean that I surrender it to you. If I deposit something with the bank, I can retrieve it because it still belongs to me. There could be a huge difference in understanding, especially with the Chinese version. It completely changes the court's intention if you use the word 群方 instead of 高语. Ms. Lai, anything to add? The section says that if a court or magistrate order that a person be disqualified, then the court or magistrate may ask the relevant person to deposit the licenses with the court or magistrate. When the license is being suspended, after the suspension period is over, the license will actually be returned to the relevant person. As to the use of words surrender or deposit, we note the comment. We have not made any changes to the word deposit in Section 71, Bracket 2. This is a word that we have always used. We have not made any amendment to it. Mr. Lam? I understand that you have not made any amendment to the word deposit in subsection 2. The amendment this time around is about EDLs. Just now you confirmed that you are using the old set of laws to apply to the new practice. I note your explanation, but I'm not satisfied. I don't think that it will cause a big impact when the officers are enforcing the law, but as we are amending the ordinance, why don't we make things better? The administration, please consider. If there's no further questions, please continue. Thank you, Chairman. Now we've come to Clause 9 of the marked up copy. Clause 9 of the bill, that's page 10 of the marked up copy. Clause 9 well, we are going to add after section 110, 1108, and 110B. 1108, Commissioner may specify form of electronic driving license, etc. That is the form of an electronic driving license, electronic driver license, a driving instructor license, or one or more electronic platforms. The license must be displayed or obtained from the specified electronic driving electronic platforms. The Commissioner may specify the form by way of notice published in the Gazette and is not a subsidiary legislation. Drivers may, through IM Smart or the e-licensing portal, display or produce their EDLs. 110B, circumstances under which persons regarded as not having produced electronic driving license, etc. If the license is not displayed on an electronic device through an electronic platform specified by the Commissioner, or if the license cannot be read or scanned by the letter because of the defect of the electronic device on which the license is purportedly displayed, or the person fails to comply with a reasonable request by the officer to facilitate the reading or the scanning of the license, then the person is to be regarded as not having produced the electronic driving license. Thank you. Under 11A bracket 1 bracket C bracket 3 is not a subsidiary legislation that is not subject to a negative vetting by the Legislative Council. We have asked the administration how they will make the public become aware of the change in the form of the electronic driving license or electronic driving instructor license, or the change to any electronic platforms. And we asked the administration if it's appropriate to have the notice be a form of subsidiary legislation. The administration replied by quoting Cap 374, that is, the forms are related to taxi fleet regime and other licenses is not subject to subsidiary legislation or negative vetting either. And they said that the amendment to the form or electronic platforms are mostly technical. They will adopt a multi-pronged approach to publicize the relevant amendments. For details, please refer to LS 24. We'll see if the administration have anything to add.
Move.
Mr. Leung. Thank you, Chairman, and thank you, Legal Advisor. The Legal Advisor has summarized our reply in details. Now, why we are not making this a subsidiary legislation, it is because the amendment notice is only in relation to the format of the notice. For detailed or substantial changes, we will still have to go through the LegCo. Since we are only specifying the technical requirements of the format, we think announcement by way of gazetted notice would suffice. Mr. Chan Shih-hung, now I agree with the government's reply. I have another question arising from the previous meeting. I think this is the opportune time to raise it. Section 110A, Commissioner may specify form of electronic driving license and also electronic driving instructor's license. Now, under the bill, the Commissioner may publish a notice on the Gazette to specify the form of the EDL. So what about the probationary driving license? Are their formats the same as the full driving license? Does Section 110A also covers learner's license or probationer's license? Ms. Amy Lee. Thank you, Chairman, and thank you, Mr. Chan. The term EDL covers all kinds of licenses, including probationary license and learner's license. The formats are the same. So the electronic format specified by the Commissioner will cover all existing paper-based licenses. Thank you. Please move on. Clause 10 of the bill, pages 11 to 13 of the markup copy. Clause 10 amends Section 111 of the Ordinance. EDL and electronic driving instructor licenses will be made part of subsection 2 of the Ordinance to provide for the offences concerning forgery of these documents. And also there are textual changes to subsection 1. Legal advisor. The new section 111 subsumes driving licenses and electronic driving instructors' licenses into the offences. The penalty level is a fine as level 3 and imprisonment for 3 years, the same as before. Now, concerning the severity of the punishment, we have also made reference to other pieces of legislation. For example, the merchant shipping ordinance. Now, if seamen do not have the relevant qualifications or licenses, they will be subject to a fine of level 3, a level 5, and also imprisonment for 2 years. So, concerning the proportionality of the offence and the punishment, has the government considered similar ordinances? Mr. Leung. Thank you, legal advisor. First of all, the tier of the fine and also the imprisonment term remains the same. So we think this is proportional to the offence. The offence in question is forgery of documents. So in terms of the level of fine and the length of imprisonment, we think we need to reflect the severity of the offence. So we consider the proposed and the existing punishments appropriate. Mr. Chan Siu-Hong. Thank you. Section 111, forgery of documents. All along, it refers to paper-based documents. Now, because of the proposed electronic driving license, we are adding subsection 1A and B. That part is clear. But if you refer to the substance of subsection 1, it's basically the same. You are just changing it to forges or alters or uses or lends to or allows to be used by any other person, a document or other thing to which this subsection applies. Now, for EDL, in EDL's context, there are two scenarios. One, you take someone's password and downloaded the app on the phone, and you are logging into the account with someone else's password. Then you can have on your phone an electronic driving license that is of somebody else. So EDL is made part of the offense of forgery of documents. However, in subsection 1A and B, you're still using the terms document or other thing. It is quite difficult for someone to make the jump from documents or other thing to an electronic driving license. So can I seek a clarification with you? Do documents or other thing cover something that I downloaded with someone else's password? DOJ, Ms. Lai. Thank you, Chairman, and thank you, Mr. Chan. Now, the term document. For the purpose of this bill, we will follow the definition for documents in the Interpretation and General Clauses Ordinance. That is presentation of information in terms of text and symbols which is described or written on any material. So the definition is wide enough to cover EDL. Mr. Chen, understood. Another scenario. Now, some elderly people may have a mobile phone, but they are not very good with it. So they would ask a family member to help them download the app on those family members' phone and give them their account and passwords so that they can display the driving license for them if necessary. Is that legal under the law? Mr. Percy Leung. Thank you, Chairman, and thank you, Mr. Chen. The issue exists even without EDL. Some elderly people would ask their family members to help them present or produce their documents. Now, let's say if you are a driver and you are required to produce your driving license when you are driving, you may ask your passenger to find the driving license or display the EDL for you. So it depends on whether the authorized officer finds it reasonable. If forgery is involved, then the authorized officer will deal with the case differently. Now, I think if you are driving, it is okay to ask your passenger to display your driving license for you. But for other scenarios, that may be problematic. So the chairman is correct. If there is an elderly driver and next to them is the driver's son, so the elderly person might have given their password for the app to the son. That's very common. So when the authorized officer asks the driver to switch off the engine and presents the EDL, then the son, who is the passenger, takes out his phone and bring up the EDL. So will it cause the authorized officer to suspect that the passenger is producing the driver's EDL illegally? Mr. Leung from the police. Thank you. Now, our frontline colleagues would ask the driver for their ID card and also the driving license. So when a car is stopped, if the driver is an elderly person, the passenger may provide help to bring up the EDL. Now the point is whether the EDL belongs to the driver themselves. Whether it is the passenger who is helping the driver is of little significance. It is whether the driver driving the vehicle has a valid license, and the frontline officers would exercise their discretion. This clarification is important because I have received inquiries from my friends. What if my mobile phone runs out of battery? And when asked, I cannot provide my EDL on my mobile phone, but I have a passenger with me, so I may borrow their phone to log into my account to present my EDL. So does that mean that the driver has discharged his duty? Mr. Leung? Or Mr. Leung from the police? Thank you. Now, the EDL is linked with the I'm Smart. So it is linked to one phone only. So if my phone has run out of battery, then I can't bring up the EDL on another person's phone. Now, on the other hand, in the future, Whether it is EDL or a paper-based driving license, a frontline officer will enforce the law according to the same yardstick. Let's say if there is an accident, we will ask the driver to present the ID card and the driving license. Now we are asking for the paper-based license. In the future, we will also accept EDLs. If there is no network or if there is no battery, our colleagues still can still check the ID card with the back-end system. Now the police department has a link system with the TD to facilitate our work. So if the phone has run out of battery, or if the driving license has been lost, then the frontline officers will decide on the following steps according to the actual situation. If they deem this situation If the deem is necessary, they may prosecute the driver with the Form 570. There is a charge under which the driver failed to carry the paper-based driving license with them. Now, after the bill is passed, we can still issue a fixed penalty ticket to the driver with the same form. Thank you, Mr. Leung. But I think the answer is you cannot bring up your EDL with another person's phone because it is linked with the I'm Smart. Well, I will need some clarification here. First, you can use the I'm Smart to link up with the EDL, but there is also a website run by the TD. You can log on to the website with your account and password on site. Whether that smartphones belong to the driver or another person is irrelevant according to the bill. I can easily borrow Mr. Duncan Chew's phone to log on to the website. Mr. Chan, you mentioned two scenarios, and I think both scenarios are different. Now, according to Mr. Leung, the police officers can check the ID card with the back office, and that will solve the problem. So my question is, if for some reason I cannot log on to I'm Smart myself, I can still use another person's phone to log on to the website of the TD. The important thing is the police officers will not deem that the driver has failed to produce the driving license to them. Is that clear, Mr. Leung? So if I use another tool to produce my EDL, that should be acceptable.
多謝議員，我諗個重點咧就係同時喺
Thank you. Our colleague will make a judgment at the scene according to the prevailing circumstances. Dr. Lo Wai Kwok, thank you. I have two questions. If a driver's mobile phone runs out of battery, for example, or is not connected to the internet, can they borrow their phones from their friends to display or produce their EDLs? And will they be regarded as having complied with the request? Or should the driver be asked to present their EDLs at the police station within 72 hours? Will the scenario that I just described regarded as having produced the EDL? Mr. Leung? Thank you. As far as I understand, the driver has to produce their EDLs. For foreigners, they have to obtain driving license via a web-based platform. For local drivers, they have to connect their EDL application with IM Smart. Just now you said that police officers have way to verify the driving license of a driver. That's what you said. What I was saying is that if the police officers have way to check if a driver holds a valid driving license, then would the completion of checking regarded as having complied with the requirements. While we handle each and every case differently, our colleagues can access our backend system to see if the drivers hold a valid driving license. They will have regards to the actual circumstances as to why the drivers were not able to display or present the EDLs. The enforcement officers will have regards to the actual circumstances to make a judgment. So it's possible that under certain circumstances, the drivers may not be asked to produce their EDLs or driving license at the police stations if the police officer can verify if the drivers hold a valid driving license. Yes, you are right. My second question on the paragraph about forgery of documents. The offender is liable to a fine at level 3 and to imprisonment for 3 years. You have not changed the penalty level. I know that there is not a way for us to determine or come up with a formula to calculate or to correlate the severity of the offense and the penalty. I don't think that it's reasonable to imprison someone for 3 years in such a circumstances. And I'd like to know the level of fine and penalty handed down by the court previously. That's exactly the question asked by the legal advisor, whether the penalty level is proportionate. Thank you for your question. We've looked into the proportionality issue. We think that forgery of electronic documents is as serious as forgery of physical documents. Regarding the penalty of a fine at level 3 and imprisonment of 3 years, we have made reference to similar laws. Well, actually, it depends on the policy intent of the ordinance. In some ordinances, say for example, Cap 134, a dangerous drug ordinance, or Cap 217, ammunition ordinance, anyone providing falsified information, then they will be subject to a fine at level 3 and imprisonment for 3 years. We've consulted the prosecution branch of the DOJ. There is not a rule on the number of years of imprisonment that have to correspond to the level of fine. We think that we have to put in place a penalty level that is proportionate or the same as forgery of a physical document. I'm not satisfied with the explanation. I don't find the penalty level in existing legislation proportionate. Mr. Tan Kan-chiu, thank you. On revocation of driving license, you said that the court will know what license the driver holds, including international driving permit. If the court orders that a driver surrenders all their licenses, what if they told the court that they've lost the license? How do you make that person surrender the international driving permit? Because they may claim to have lost the permit and use it in other countries. Would that constitute a case of forgery of documents? Are they using a falsified driving license? Anyone? Mr. Lang? Thank you, Chairman. Thank you, Mr. Chiu. If a court makes an order asking the person to surrender all licenses, then the traffic headquarters will receive the same order immediately, and we will input the relevant information in the backend system. So holders of physical or electronic driving license will be subject to the same arrangement. The police and the transport department will be made aware of any order made by the court. As far as we understand, if you want to rent a car in other countries, you have to produce both your international driving permit as well as your valid driving license, that is the green card. After a court has made an order, then the clerk of the court will ask the driver to produce the licenses immediately. Thank you. If you claim that you've lost your international driving permit and use the same permit to rent a car somewhere else, I think what Mr. Chu was saying is that how the foreign car rental companies verify the validity of their driving license, because we don't have a common network. I don't think that the rental companies would check the validity of my driving license because they don't have the power to do so. Is my understanding correct? Transport Department, please. Your understanding is right. This is an individual act. I must stress that according to the court's order, if someone has their driving license suspended, then they have to comply with the court's order by surrendering all the relevant documents and licenses. Say, for example, if someone lies, then they would be in the wrong. It's not about whether it's international driving license or the green card, the local driving license. As long as they lie, they are in the wrong. You need to have an insurance cover if you rent a car somewhere else, and if things do happen, accidents do happen, then the insurance companies would know that they're driving without a valid driving license. No other questions. Thank you. Now we've come to Division 2 of the bill. That's about road traffic driving license regulations, Cap 374B. We've come to Clause 11 of the bill. That's page 14 of the marked up copy. Clause 11 amends Regulation 2 by repealing the definition of driving instructor's license. As mentioned in our last meeting, we have included the definition of driving instructor's license in the principal ordinance. Clause 12, that's page 15 of the marked up copy. Clause 12 is to amend Regulation 44A. It's about the power of commissioner to require production of license. Anyone who produced the e-driving license would be regarded as having complied with the requirement. No question. Clause 13 of the bill, that's page 16 of the marked up copy. Clause 13 amends fifth schedule of the regulation. We amend both the Chinese and English version of the ordinance. We allow the driving instructors to hold the electronic driving license or carry or be able to readily avail himself or herself of an electronic device on which their electronic driving instructor license can be readily displayed, and as long as they can show their e-driving instructor's license, then they would have complied with the relevant requirement. No question. Thank you. Now we've come to Division 3 of the regulation. That's about Road Traffic Parking Regulations 374C. Now we come to Clause 14 of the bill. That's page 17 of the marked up copy. Clause 14 amends Regulation 27BA. We will consider displaying or producing e-driving license as having complied with the requirement to produce driving license. No question. Now we've come to Part 3, related amendments. It's about housing traffic bylaws. We have already dealt with the road traffic regulations and ordinance. There are other regulations that we have to amend because currently, other than police officers who take enforcement officers at tunnels or restricted zones, there are authorized officers who are empowered to ask the drivers to produce their driving license. Therefore, after introducing the EDLs, we must amend all relevant ordinance and regulations in tandem with the implementation of EDLs. I will explain each and every of the amendments. We have made reference to Clause 9 of the bill. That's about Cap 37411B, 110B. This scenario stated thereunder, that is, if a person does not show the EDLs on the electronic platform specified by the commissioner or does not comply with the order of the officers to make their licenses readily available, then they would have committed an offense. Now, I will talk about the amendments one by one. Division 1, that's about housing traffic bylaws, Cap 283A. That's Clause 15 of the bill, page 18 of the marked up copy. Clause 15 amends Bylaw 18. We also accept the production of electronic driving license. We have included the description of EDLs and included scenarios where failure to produce is described.
Legal advisor, please. Now, Cap 374, Section 110B, concerning failure to produce the EDL, the same reference appears in Part 3, the related amendments to other ordinances. Now, in moments, when we come to certain parts of Part 3, for example, Cap 357L and 661, there are reasonable excuses for offenses in relation to failure to produce EDL. However, for other legislations mentioned in Part 3, there are no reasonable excuses as a defense. Now, we have written to the administration and inquire whether we need to maintain the consistency among the legislations in Part 3 and provide reasonable excuse defense for all the legislations. Now, according to the administration, the requirements to produce EDL or driving license are made based on various policy concerns or policy intentions, so it is not suitable to provide an across-the-board reasonable excuse defense for all the legislations. Mr. Lam, Mr. Leung, any supplement? The legal advisor has explained the matter clearly. Thank you. Please continue. We have come to Division 2 of the bill. Amendments in relation to waste disposal, designated waste disposal facility regulation, Cap 354/L. Clause 16 of the bill, pages 20 to 24 of the markup copy. Clause 16 amends Cap 354/L, Section 4. Producing an EDL would suffice to discharge the duty to produce a driving license, and also the provision provides for scenarios where an EDL cannot be provided. Part 3, Division 3, in relation to Road, Tunnels, Government Ordinance, Cap 368. Clause 17 of the bill. Pages 25 to 26 of the markup copy. Clause 17 of the bill amends Section 11 of Cap 368. Production of EDL will be regarded as having complied with the requirements of producing a driving license, and also it provides for the scenario where an EDL cannot be produced. Please continue. Thank you. Next, Division 4, Road Traffic Driving Offence Points Ordinance, Cap 375. We are now at Clause 18 of the bill. That's page 27 of the markup copy. Clause 18 amends Section 10 of Cap 375. It's a technical amendment on the Chinese text. No question. Please continue. Next, Clause 19 of the bill. Page 28 of the markup copy. Clause 19 of the bill amends Section 11 of Cap 375. It's also a textual amendment. No question. Please continue. Thank you. We are now at Division 5 of the bill. Airport Authority Bylaw, Cap 483, /A. Clause 20 of the bill. That's pages 29 to 20 on the markup copy. Clause 20 amends Section 56 of Cap 483, /A. Producing an EDL would be regarded as having complied with the requirements to produce a driving license, and also it provides for a case when an EDL has not been produced. Clause 21 of the bill. Pages 31 to 32 of the markup copy. Clause 21 amends Schedule 2 of Cap 483. Modification of Road Traffic Ordinance. Now back in Clause 6, we have made an amendment. This is a corresponding amendment. No question. Please continue. Thank you, Chairman. We are now at Division 6 of the bill. In relation to Chain Mark Control Area Ordinance, Cap 498. Clause 22 of the bill. Pages 33 to 4 of the markup copy. Clause 22 amends Section 13 of Cap 498. Producing an EDL would be regarded as having complied with the requirements to produce a driving license. It also provides for scenarios where EDL has not been produced. Please continue. Division 7. Discovery Bay Tunnel Link Ordinance, Cap 520. Clause 23. Pages 35 to 36 of the markup copy. Clause 23 amends Section 29 of Cap 520. Producing an EDL would be regarded as having complied with the requirements to produce one's driving license. The provision also specifies scenarios where EDL has not been produced. Mr. Andrew Lam. Now, there are 13 pieces of legislation with corresponding amendments. I'm raising a question here because in bracket 7, there is a definition for drivers. However, for the 13 pieces of legislation with related amendments, the term or definition for driver does not exist in every one of them. It does not affect your bill directly, but in reality, The definition for driver may change in the future. The definition at present may not apply. Of course, there wouldn't be a problem if the driver is a human being, but in the future, the driver may not be a human being. So that's why I'm bringing up this question to you. Any reply? Deputy Secretary. Mr. Andrew Lam has a very sound logic. Now, 2 years ago, we have amended CAP 374 to deal with unmanned vehicles. Now, in the future, if there is a reference to unmanned vehicles in the ordinance, then we will have empowered the government has been empowered to interpret the definition. Now, for principal matters, the Commissioner or the Secretary for Transport and Logistics will have to interpret the definition. For technical interpretation, the Commissioner for Transport can do so. Now, that amendment has defined the capacity of the real driver or the motorist. Thank you, Chairman. I don't have full grasp of the background. But I think many of our ordinances are still referring to a person rather than a computer system. So I think there are still wrinkles to be ironed out. Now, since we are amending Chain Mark Control and Discovery Bay Tunnel ordinance, I think it might be a good chance for us to amend the definition for driver as well. But we have time. No further question. Please continue. Thank you, Chairman. We're now at Division 8. Mass Transit Railway Transport Interchange Bylaw, Cap 556 D. We're now at Clause 24, pages 37 to 8 of the markup copy. Clause 24 amends Section 29 of Cap 556 D. Producing an EDL will be regarded as having complied with the request to produce one's driving license, and also scenarios where driving license is not provided has been provided for. Clause 25 of the bill, page 39 on the markup copy. Clause 25 amends Schedule 2 of Cap 556. This is a textual amendment. Please continue. Thank you, Chairman. Division 9 of the bill, Chain Sha Control Area Ordinance, Cap 594. Clause 26 of the bill, pages 40 to 41 of the markup copy. Clause 26 amends Section 13 of Cap 596. Producing an EDL will be regarded as having complied with the requirements to produce one's driving license. And also, the provision has provided for scenarios where driving license has not been produced. Division 10, Motor Vehicle Idling Fixed Penalty Ordinance, Cap 611. Clause 27 of the bill, page 42 of the markup copy. It amends Section 9 of Cap 611. Producing an EDL will be regarded as having complied with requirements to produce a driving license. And also, it provides for scenarios where one is deemed not to have produced the EDL. No question. We have completed scrutiny of the entire bill. Thank you very much. Now we have completed our scrutiny work. Now, according to usual practice, we have scrutinized the Chinese text of the bill, and we will ask the legal advisor to help us scrutinize the English text. Now, members, if you would like to propose amendments to the bill, please do so by 5 p.m. on Wednesday, the 7th of May. Please send the drafts to the Secretariat. The Secretariat will follow up with the administration on the timing of resumption of second reading of the bill, and you'll be notified in due course. If there are no questions, our scrutiny work is completed. Thank you for attendance. Meeting is adjourned.